It's really a pleasure to present Theresa Maria Strombach now. She's a student assistant at our center with a double background in legal history and in linguistics. She studied Germanistik, vergleichende Literatur und Kulturwissenschaft, how it is named in German, with Rechtswissenschaft as second subject. So you might be interested in the nomination of those topics, whereas the master aims at Germanistics with a linguistic focus. Besides her work at the Center for some 2-3 years, Theresa, since November 2017, has been working for the long-term project in dialectic varieties. You might know it, the Dialektatlas Mittleres Deutschland. This is a kind of institution that gave professional socialization to generations of linguistics in Germany, as you might know, the specialists. And it's really a pity that those who work with you can't come over because of the Warsaw Conference about linguistics. You will know it's just today, so it's really a pity. From my side, I'm curious to see how these competences might lead to a multidisciplinary result in the field of a cultural analysis of the law. Her topic will be as follows: conditional structures in German legal text, a comparison between the German and the Swiss Penal Code. We're looking forward to your reading of two different penal codes in the light of their syntax structure and what this might mean in the end for comparing two legal cultures of penal imputation. So the floor is yours. Good luck. Go ahead.
Yes, thank you very much. I know that we're running out of time, but first of all, I have to say thank you for having the opportunity to give a talk in this special context and company. The topic that I will be speaking about arises from a small study that was also part of my bachelor project in summer semester 2017. I am therefore really looking forward to put up the results of my research for discussion afterwards. As the title already suggests, my project primarily dealt with an analysis of German and Swiss legal texts. The subject of this comparative analysis were different types of conditional structures, so I am looking at legal language from a primarily grammatical or more exactly syntactic perspective. Therefore, I must first introduce how conditionality serves as a linkage strategy in German legal texts. Afterwards, I am going to present those conditional structures in regard to their linguistic form, their positioning within a sentence, and their functionality. But the main part of my talk will deal with the methodology and results of my corpus analysis, which looked for conditional structures first in the special part of the German Penal Code, and second in its Swiss counterpart, the special provisions. Finally, the comparison of these two legal texts might also cast light on diatopic variation as a possible indication of divergent legal cultures. When talking about the connection of Tatbestand and Rechtsfolge, you can already see the difficulties that I get into when trying to translate such terms. It is obvious that the basic structure to express a legal rule is a conditional one, following a pattern like: wenn der Tatbestand X der Fall ist, dann gilt die Rechtsfolge Y. Therefore, a conditional structure is a text-type specific realization of legal speech actions, but the main issue is how different types of conditional structures behave in regard to their frequency in German and Swiss legal texts, and whether their occurrence can be seen as an international text-type convention or as an expression of legal cultures. First and foremost, the wide range of conditional structures can be divided according to their so-called Satzwertigkeit, or in other words, whether these structures include an independent clause or not. We therefore have conditional clauses on one hand, and alternative syntagms with conditional meaning on the other. As the most common conditional pattern comparable to the English if clauses, German conditional clauses can either be introduced by a subjunction like wenn, or they can occur as an unintroduced clause with its verb in first position, or they can occur as a generic relative clause introduced by wer. Moreover, the distinction of these clause types focusing either agent or act indicates the contrast between Tatstrafrecht and Täterstrafrecht, so whether criminal law is based on the offense as the act or on the offender as the agent. The group of alternative syntagms with conditional meaning could also be expanded, but the following analysis will concentrate only on conditional clauses, strictly speaking on the comparison of introduced and unintroduced conditional clauses. Categorization of subjunctionally introduced conditional clauses is naturally based on conditional subjunctions, as I would like to demonstrate by using some examples from my corpus. I have to apologize for only showing a German version of these examples, but every translation might and probably will change those specific conditional structures that are in the focus of my later analysis. So, the prototype of generic connectors is the German subjunction wenn, not only containing a conditional but also a temporal meaning. Whereas this first example includes a fairly clearly conditional when clause, the second example also allows a temporal interpretation. Such a double meaning is characteristic of legal deadlines, further conveyed by other temporal expressions like spätestens or unverzüglich hier. But a clause introduced by falls instead of wenn is undoubtedly conditional, so the choice of falls instead of wenn might also lead to semantic disambiguation. The subjunctions sofern and soweit finally form a group called conditional restrictive connectors, because they are not only expressing a pure conditional relation, but are also restricting a given rule under certain conditions. In contrast to the introduced conditional clauses, unintroduced conditional ones are completely independent of polysemic subjunctions. They are therefore an unambiguous pattern to express conditionality. Another thesis can also be developed due to this fact. It can be assumed that conditional clauses with a verb first position do not only appear as a phenomenon of written language, but also in specific contexts. The distinction between introduced and unintroduced conditional clauses is based on their synthesis, so they can also be called synthetic and asynthetic conditional clauses. The attached scheme shows how a subjunctionally linked conditional clause works on a syntactic level. Condition and consequence are linked by a conditional subjunction, creating a hypertactic sentence structure. At first sight, only the column in the middle has to be deleted in order to apply the scheme to asynthetic conditional clauses. But that would lead to an almost paratactic construction, turning the distinction of condition and consequence into a merely topological question. At such a topological level, there are ultimately three possibilities to position a conditional clause within a complex sentence. The clause can either be placed in the Vorfeld, Mittelfeld, or Nachfeld. But by expressing a logical relation between a condition as the causing and a result as the caused event, the Vorfeld position is nevertheless clearly preferred. These left peripheral constructions divide into three different patterns again, mirroring the evolution of conditional syntax in the process. The integrative top position as the last stage of development has a conditional clause in the Vorfeld, while the verb takes the second position. By inserting so as an anaphoric correlate, not only the conditional clause, but also the resumptive is, as a result of left dislocation, placed in the Vorfeld. But if a phrase other than the correlate takes the original verb second position, the conditional clause is disintegrated and placed in the so-called Vorfeld. But the third pattern is actually restricted to spoken language and can therefore be neglected in the following examination. The last dimension of conditional structures concerns their function. In legal texts, conditional clauses mostly do not appear as isolated sentences, but within the context of complex constructions. Those constructions expressing legal rules can be extended and restricted, as well as subjected to exceptions by using focus and negation particles, for example. Such a functional classification of conditional structures might eventually lead to a description of their roles in legal texts. My first point of research addresses the special part of the German Penal Code, which is the main criminal code standardizing the so-called Kernstrafrecht, so the core areas of criminal law in the Federal Republic of Germany. When remembering the logic of imputation in German criminal law, which entails a fundamental distinction between the stages of Tatbestandsmäßigkeit, Rechtswidrigkeit, and Schuld, it becomes apparent that the general part contains such fundamental provisions concerning unlawfulness, criminal responsibility, and assessment of penalties, whereas the single Tatbestandsmerkmale, translatable only with difficulty as specific elements of the penal norm, are mostly laid out within the special part. Therefore, norms of the special part are especially suitable for analyzing conditional relations between offense and consequence. 199, so nearly 54% of its 370 paragraphs, include at least one explicit conditional clause. Such a high frequency already emphasizes the relevance of these structures. But only an eighth of the extracted paragraphs contains synthetic and asynthetic conditional clauses in combination, so there might be a specific role allocation between those types. Synthetic conditional clauses can be determined by their introducing subjunctions. Of the total 271 occurrences, about 90% are attributable to when as a not only frequent, but even prototypical conditional subjunction. My presentation will focus exactly on these when clauses. Their position within the whole construction serves as a first criterion for classification. It is evident that when clauses prefer to stand post-positioned in the special part of the German Penal Code. With regard to functional aspects, when clauses express additional conditions that establish a scope, give a definition, refer to the Tatbestandsmäßigkeit, the unlawfulness or criminal liability of an offense, or assess penalties by arranging mitigating or aggravating conditions. Clauses assessing penalties often create less serious and especially serious cases, like the rule example, Regelbeispiel, in paragraph 243, which establishes an especially serious case of theft. The following example shows when clauses defining the scope of a basic offense by means of intertextual references as well as focus and negation particles, like auch, nur, and nicht here. Whereas the first clause forms an exception, the second broadens the scope. The third clause, limiting the law scope, uses the demonstrative pronoun dies as a complex anaphora referring to the basic offense. My second example includes a when clause that further determines the unlawfulness of a certain offense. In paragraph 228, it is stated that bodily harm, which is caused with the consent of the injured person, is only unlawful when violating die guten Sitten, being contra bonus mores, offending common decency. In other words, an immoral, unethical injury is presumed unlawful despite the injured person's consent. The norm thereby restricts the unlawfulness of assaults with the help of a postposition when clause, which is assigned to the main clause by means of the correlate dann and the restricting particle nur. I'm sorry, I forgot to push a button. Die guten Sitten still remains an undetermined legal concept, as the multiple translations above already suggest, so its vagueness opposes the specification of unlawfulness. Asynthetic conditional clauses lack any subjunction, so they can only be extracted and classified on the basis of their introducing verbs. In total, 1 in 4 paragraphs within the special part include such an unintroduced conditional clause. Although there are many possible verbs to introduce such a V1 clause, I could detect some favorite verbs, among them sein, werden, handeln, and verursachen. Another criterion affects the positioning and integration of these V1 clauses within the whole construction. In general, there is no single V1 clause in the whole special part of the German Penal Code which is not prefixed. About 93% of these clauses are followed by a correlate, so the resumptive top position can be regarded as the overall rule, and the integrative top position as a rare exception. From a functional perspective, asynthetic conditional clauses verbalize external conditions concerning the circumstances of committing a crime, the criminal liability of an offense, or the assessment of penalties. Such framing preconditions of sentencing can be detected in the following examples. Paragraph 213, which already bears the title Minder schwerer Fall, determines that a crime of passion has to be considered a less serious case of homicide when fulfilling the qualifying constituent facts of the offense. But asynthetic conditional clauses can also express an aggravating combination of two offenses, like in paragraph 255, qualifying the basic offense of extortion by adding the feature räuberisch. The punishment of an extortionist is thereby put on the same level as a robber's penalty if the means of coercion of a robbery apply. Time for first summary. Asynthetic and synthetic conditional clauses seem to act on different levels of conditioning. Whereas preceding asynthetic clauses construct fundamental framing conditions like qualified offenses, for example, post-positive synthetic clauses express extending, limiting, and acceptive conditions. The second part of my corpus analysis focuses conditional structures in the special provisions of the Swiss Penal Code as the main criminal code of Switzerland, which is, at least when it comes to structure, quite similar to the German Penal Code. It is therefore particularly suited for comparison. In analogy to its German counterpart, the Swiss Penal Code contains its specific sanction norms in a section called Special Provisions, while the basics are treated within the general provisions. In addition, the third book deals with the law scope, so this area seems to be outsourced somehow. In order to create a comparative basis, it is necessary to structure the following analysis just like the previous one. Thus, the frequency of explicit conditional clauses in the special provisions comes to 46%, a statistic which at first observation reveals one fact. There are less conditional clauses in the Swiss than in the German corpus. But again, only 90 occurrences of conditional subjunctions are mainly reducible to the prototype then. About 3/4 of these then clauses are post-positive, whereas the remaining quarter is placed parenthetically. The different functions of then clauses within the special provisions are primarily comparable to the categories already discussed in the third chapter. They are expressing additional conditions regarding the law scope, its conceptual definitions, the criminal liability of a certain behavior, or its assessment of penalties. But the following article that exemplifies an aggravating condition shows how legal terms can diverge from each other even though they arise from the same language. The offense of money laundering, called Geldwäscherei in Switzerland instead of Geldwäsche like in Germany, was established in 1992 in order to counteract the frequent misuse of Switzerland as a transit station for illegal money. The aggravation of sentence applies in particular to 3 alternative constellations, which are regarded as a serious case, but not as an especially serious case here. Namely, an organized, a gang-like, or a commercial perpetration. Because of their higher frequency in the Swiss corpus, I don't want to go completely without parenthetically placed clauses at this point, but discuss a single example instead. This integrated when clause defines the success, or at least the attempt of an act, as the basic condition of the offense's criminal liability. It thereby implies a central criterion to distinguish between suicide and homicide. A selfless participation by inciting or assisting suicide goes unpunished inasmuch as the person wishing to die commits or attempts to commit suicide under control and with sole responsibility. Therefore, Article 115 serves as the legal basis of assisted suicide, which is being widely discussed as being potentially legal in Switzerland. 30% of all articles within the special provisions contain at least one asynthetic conditional clause. These asynthetic clauses prefer to begin with rather universally applicable verbs like handeln, sein, werden, or haben. A clear positional pattern is apparent since, with one exception, all of these clauses are placed in resumptive top position. In addition, most of them introduce a section or even a whole article, so they can be classified as framing conditions. Besides specifying scope and prosecution, the one clauses are mainly used to develop aggravating or mitigating qualifications of a basic offense. The contrast between those two extremes can be demonstrated by means of murder and manslaughter. Whereas Article 111 forms the so-called Auffangtatbestand, the omnibus offense of attentional homicide, Article 112 provides for aggravation if a murder criterion applies, and Article 113 enables a mitigation if the offense was committed in the heat of the moment. The V1 clauses not only express qualifications of an offense, but also alternative or separate offenses. Thus, the asynthetic conditional clause in my last example is introduced by a complete verb that is explicitly verbalizing the delict in question. Thereby, infanticide is placed between abortion and homicide in general, not only temporarily, but also concerning its penalty. Time for a second summary. While synthetic conditional clauses phrase additional facts of an offense, asynthetic clauses typically establish a qualified initial constellation with divergent consequences. Finally, I would like to compare the results of both analyses with regard to a formal, positional, and functional specialization of conditional structures. By belonging to the same legal sphere but to different language areas, the German and the Swiss Penal Code cannot just be compared with respect to their concrete frequency of conditional clauses, but such a comparison also inquires about the existence of diatopic variants in German legal language. At first, it is obvious that the German norms are on average much more complex than the Swiss provisions. What the problem comes down to is whether this difference in complexity can be attributed to the frequency of conditional clauses. The following table shows that the proportion of paragraphs with conditional participation in a special part is only insignificantly higher than in the special provisions. But by comparing the frequency of the two clause types in relation both to each other and with respect to complex conditional constructions, it can be seen that the special part prefers to express conditional relations by means of synthetic clauses, and the special provisions tend to use asynthetic conditional clauses, as is apparent from my now very last example. Generally, the following prototypic role allocation can be discerned. An initial framing condition or qualification of offense tends to be realized as an unintroduced V1 clause with resumptive topposition. A postpositive subjunctionally introduced clause, on the other hand, phrases a specifying additional condition. Besides, these findings correlate with the prototypic German and Swiss maxims of legislation. In order to guarantee maximum precision while regulating numerous variants of offenses, the German special part uses primarily synthetic clauses, for example, within the context of rule examples, as a typically German technique. In comparison, the criminal norms of the Swiss special provisions undergo an abstracting typification, probably depending on Helvetic traditions like, for example, the Eugen Huber rule, not only pursuing the goal of a high-clarity legal drafting, like Stefan Höfler calls it, but also rising to the challenge of multilingualism and diglossia. So the general functionalization of different conditional structures can be considered a cross-border and thereby text-type specific feature. But the deviant frequencies of synthetic and asynthetic conditional clauses suggest an area-specific connection of crime and penalty, regarding forms of imputation as social facts and thus reflecting divergent cultures of criminal law, which could also be analyzed in the light of the law as culture paradigm. These cultures of criminal law and imputation become perceptible by facing the syntactic structures of their legal texts and by identifying them as predominantly conditional. When attributing precision and determination to German criminal law while characterizing its Swiss counterpart as striving for clarity and intelligibility, the diatopic allocation of conditional structures might eventually dare to establish a system of conditional variation in legal texts. Thank you very much for your attention.